Hello and welcome to the first ICA LinkedIn Live. My name is Tim Tyler. I'm the Vice President of the ICA and I'm delighted to be joined by James Rickett, the Global Lead for Anti-Money Laundering and Sanctions Compliance within the ICA. Over the next 15 or so minutes, we're going to be exploring the way in which regulatory activity and sanctions in particular have evolved over the last few years. Can I just briefly set the scene? And I'm sure that you'll be comfortable with what I'm going to say, but it's a reminder that, of course, regulators have a statutory obligation. Their role includes a number of things: consumer protection, market protection, but our focus here, of course, is in particular around reducing the opportunities for financial crime. And to meet those obligations, they ensure that there is a clear set of rules, requirements, principles governing the activity of regulated businesses. And of course, for those to be effective, then the regulators need to test our compliance with those rules, and in doing that, their effectiveness. And inevitably, that leads to fines and other sanctions being taken against businesses and potentially individuals. And I think that's where we come in, James.
Yeah.
What are your thoughts here?
Well, firstly, congratulations on being appointed Vice President, Tim, of the ICA. I think it's the first major live broadcast we've done, haven't we? So I think let me signpost for everybody watching on this evolution of enforcement. I'm going to use this term a lot because I really like it. Anti-money laundering fines are nothing new, but I think the landmark came in 2012 when the Department of Justice announced HSBC's fine. And why I call that landmark was this started to adjust the barometer of civil and criminal liability, and there was some criticism that potentially criminal liability wasn't found on individuals. But the remarkable moment, from my memory, was the first use of a deferred prosecution agreement. So that felt like the first shift in how regulators are going to enforce. Move on a few years, and very quickly, BNP Paribas, and we saw the withdrawal of a license in a certain arm of their business for a period of time. That had an impact on them. Evolving again, and we saw Standard Chartered being involved. And we've now reached present times where we're sort of on the back end of the Danske enforcement action. We're going to see how that plays out. But two pivotal moments have happened for me in recent memory that hopefully we'll unpack. First is the case of Birgit Bonnesen, the ex-Swedbank CEO, where actually now we start to see individual accountability for actions. And then, of course, a case that we spoke about before was the case of ICA Mobile. We've seen not just an enforcement action against the firm, but we've actually seen a senior manager go to prison, which is a shift in that evolution. So I think what will be useful for us to unpack today is the priorities around what regulators are trying to do. I think it's also useful to talk about the role of an MLRO and how that's evolving and senior accountability. And of course, get your thoughts on the matters as well.
So we've only got 15 minutes.
We do.
And we've already got three areas that we're looking to explore. Firstly, this move from civil to civil and criminal as a potential sanction. Secondly, the move from corporate to personal accountability. And thirdly, remind me. Thirdly,
Culture.
Well, we're going to talk about that, of course.
We did
as
say
well.
we hadn't scripted, but we kind of thought of what we wanted to talk about.
Okay. So let's start then by thinking about this move from civil to criminal, where we're seeing now for the first time the Financial Conduct Authority in the UK using criminal recourse against the NatWest, for instance. We saw that last year. I was researching this just prior to this recording, and the FCA has had the power to do that since 2007. They've chosen not to do it. Now, for the first time, they're taking that criminal prosecution against NatWest. How do you see that?
I'm intrigued to know what precedent this sets moving forward. Now, we've spoken about this, haven't we? About are money laundering fines simply the cost of doing business? We know that firms write off provision for fraud. It's a bit of a controversial statement, but are firms writing off provisions for these fines and enforcement actions? And I'm not sure. The pessimistic arm of me says maybe. The positive part of me says it's part of the evolution of learning. But actually, Tim, I want to turn it back to you and get your thoughts, because having come from a law enforcement background, how do you think that might be perceived?
Well, of course, if we're looking at a criminal rather than a civil prosecution, it introduces a number of challenges. One is the burden of proof. Mm-hmm. It's not balance of probabilities. It's now beyond reasonable doubt. Entirely different set of requirements. And I know we were speaking about this before this recording. The experience of the FCA in taking a criminal approach is incredibly expensive. What to us was very, very straightforward. What the bank has done in Bradford seems very, very obvious, and the money laundering and the nature of the offences committed seems straightforward to prove. And yet, in evidence given by the CEO of the FCA, and I'm looking at my notes here, the CEO indicated that the investigation took 30,000 staff hours, involved 300,000 documents and 85 witnesses. So it was anything but straightforward. So it's an expensive thing to do. And of course, if you're taking a criminal prosecution, it brings with it a whole range of disclosure and other requirements that themselves are labor intensive and expensive. So it's not an easy decision to make. But of course, it's sending a message, isn't it? I think that's what the FCA is doing. They're saying, what we saw in Bradford amounts to a criminal offence. It's not enough to describe it as a civil offence. We need to go further. And of course, ultimately, people can go to prison on the back of this. And of course, you were talking before, weren't you, about an individual with like a mobile going.
There has to be a point, though, right, when you're talking about a public sector body involved in enforcement, and those numbers are staggering. 30,000 man hours. There must be a point where the regulator feels how do we change the culture of organisations to actually comply with money laundering efforts, or are the costs being passed on by the regulator to these firms? And that's where it brings up my argument again about the cost of doing business, cost of AML enforcement.
So that's a very cynical view.
It can be.
I had a conversation with a regulator. I won't say which one recently. And I suggested to the regulator that the approach that they were taking was crushing innovation, because people were frightened of the regulator. So they weren't willing to take risks. And of course, we know that if we're going to change things, if we're going to innovate, always it involves risk. It can go wrong as well as it can go right. Individuals are losing the willingness to do that. And that means that regulated businesses can stagnate. They can focus solely on meeting what the regulator requires rather than their primary goal, I would suggest, which is to reduce financial crime in the context of this particular conversation. Yeah. So there's a danger, I think, that it's got a mutating activity.
Now, there are, in my opinion, a number of different cultural issues here. The first being, of course, is I think that we are in an environment where we're quite scared of being the next Netflix special. We don't want our organisation or our face to be on there because of our findings. So actually, this now shifts, in my perspective, from the corporate issues that we've seen to the individual matters. And actually, I want to bring in the context about individuals in firms and where the evolution has taken us. So we've spoken in some detail, haven't we, about the Leica Mobile case. I believe it was a €10 million fine. The CEO was imprisoned, subject to an imprisonment. The culture around the roles and responsibilities then of these individuals. I'm an aspiring money laundering reporting officer. Why on earth would I drop myself into an organisation where there is so much risk, particularly because it looks like that there's a shift in the landscape of how enforcement actions are happening?
I think that's a really good question. And I think it's a very relevant question because we know there is a scarcity of quality money laundering reporting officers. And in some ways that's surprising, because if you step back and look at the role, it's highly rewarding because you can make a difference in protecting communities around the world, because we can make a difference in reducing financial crime. Up until recently, it's tended to be reasonably well paid, and it carries status. So why wouldn't people want to do this? We're finding, of course, that they aren't, which goes to your point, I think, around the level of risk, personal risk, that carrying an MLRO responsibility and accountability brings with it. So I agree. We've seen evidence of that within the ICA, of a reluctance to go down that road. And I think you mentioned before this recording that the FCA has been focused very much on turnover of MLROs in the last few years.
Now, I think just for everybody's benefit, we spoke around 642, 643 firms that the FCA have gone into because they have had more than 3 MLROs in a space of 3 years, which is staggering that can happen. But I want to just come back to a moment because this is where I think that we've got 2 parallel issues. We've got the rapid acceleration. No, acceleration is not the right word, but the breadth in which regulatory requirements are now spreading across. So virtual assets, real estate agents are now falling under the microscope of regulators. Fintechs. But what this has developed is now an absolute need for MLROs in this sector. Now, I'll place on record, I'm not looking for another job, but I do look and see what's happening in the market. And we are seeing MLROs being offered lower remuneration, but it's the experience, Tim, that worries me. I'm seeing MLRO vacancies for 2 to 4 years in financial crime. For me, there appears to be a significant lack of understanding on the implications for those individuals should something go wrong.
So I entirely agree. And this, I think, touches on a wider issue that I know we've been talking about, and that is that we are increasingly seeing compliance and anti-money laundering and this area that we're working within as being a profession and not just a job. If we roll this back 20 years, I don't think we could say that. We saw that people were moving between roles within regulated entities without bringing relevant experience, for instance, being appointed as the MLRO, without any meaningful experience. It was just seen as another stepping stone within the business. That I think we've moved on from, and that's good news, I think, in fairness, and I think it's good to recognize that. But your point, I think, is that in some areas, maybe startups, smaller businesses, those that don't have a pedigree and experience in this space, there is still a need for them to appoint an MLRO, but are they appointing the right people with the right experience? And I think your point is perhaps they're not, and I agree. That's alarming, of course. Yeah. Talk me through why is it alarming?
If I read between the lines, is this a tick box exercise to become regulated? And one of the concepts that maybe to unpack here is that there actually is a bit of a culture, as we've seen from that regulatory action by the FCA on reviewing the number of MLROs. Why are MLROs leaving? Now, my concern is in these smaller startup organisations that have got these vast regulatory requirements to fulfil, to even open the doors to do business. Is the role of an MLRO in these firms simply there, so seen and not heard? Is there maybe a concern that there are other priorities, commercial priorities, that are overriding the factors? Are the risk factors being identified? And is that what's driving individuals away?
And I think there's another angle to this. I wish we had the answers, by the way. All we can do, I think, in the space of just a few minutes is highlight some of the questions. That's certainly one. If we now change our focus and look at the accountancy sector, there was a report published recently by the ICA where they'd interviewed 240 MLROs, and all but one of them also had client-facing responsibilities. And you'll know, of course, that there's a strong argument to say that that begins, I'm going to choose my words carefully, but it begins to undermine the objectivity and the independence that they need to bring to that role as the MLRO. That I expect we'll be talking about again in the future collectively. But I'm mindful of the time. Can I just very, very quickly summarize where I think we've got to? And then we'll need to start to think about winding this up. We've, over the last 15 minutes, of course, we've talked about the way that regulators are evolving their approach to ensure that businesses take their requirements seriously. And there's good reason for doing this. And we're seeing 2 strands to this. On the one hand, we're starting to see regulators, not just in the UK, but elsewhere around the world, willing to use criminal as well as civil sanctions. This is opening a door to much more serious and graver possible outcomes for individuals, including imprisonment. But we're also seeing this move from corporate to corporate and personal responsibility. And I think we've recognized and talked about that can lead to a number of outcomes within the businesses that are being supervised. There's so much more that we could talk about.
Wow, there is.
I think we'll probably will continue after this finishes. But for the moment, mindful of the time, James, anything you want to say before we finish?
Not really. I mean, if I had to share a final thought, I still think we hold with bated breath to see an organisation like a tier 1 financial institution to go through something individual. So that will be, for me, the next landmark moment in the evolution of enforcement.
Okay. Well, James, thank you very much for joining me. And colleagues around the world, thank you for joining us in what has been our first live LinkedIn interview. I'm sure there'll be more to come in the future. But meantime, do take care.